Hello, and welcome to the first class of the Appellate Practice and Procedure course for Solo Practice University. My name is Todd Smith, and I'm the instructor for this course. You probably already know that from having looked at the course description and the introductory video and that sort of thing. But it's nice to get started with the course, and I hope everyone who's watching is able to get what they need from it. For today's topics, I'd like to give an introduction, and then we'll go over the course itself, the course syllabus, discuss why someone would be interested in practicing appellate law, briefly cover the anatomy of the appellate process, and also talk about the tools of the trade. You should have below my image on the video a SlideShare presentation. It was originally a PowerPoint, but I think I decided to use the SlideShare format to be consistent with what some other people were doing for Solo Practice University. So hopefully, if the technology has worked out the way that I want, you have the video appearing in the same blog post as a SlideShare presentation immediately below that, and you'll be able to view those simultaneously and hopefully get the most out of the presentation. So the first slide that you should see is an introductory slide that references class number 1, and today's subject being overview and tools of the trade. Moving on to the next slide is an overview of the topics that we'll be talking about today. And as I said, I've already gone through those, and we'll hit those one by one. Let me just take a minute and introduce myself to everyone a little more thoroughly. I am a sole practitioner in Austin, Texas. I'm a native Texan. I've been practicing law for about 13 years now, 14 years, I guess. Before I went into private practice, I spent 2 years working for a Texas Supreme Court justice right out of law school, and then practiced law at a large law firm for 9 years before 3 years ago opening my own solo practice. And so I've been doing solo practice, or I've been in solo practice long enough now where I feel pretty well qualified to discuss all the issues that we'll talk about in this course from the unique perspective of a sole practitioner, but also with the benefit of having had almost a decade's worth of experience in a large law firm and knowing, what goes into practicing in that environment as well. So my solo practice, I've had for almost exactly 3 years now. June of 2006 is when I started. I came straight from the big law practice to solo law practice, and it was an adjustment, but it was a positive adjustment. And so I was thrilled, of course, when Susan asked me to teach this course on appellate practice and procedure so that I could help other sole practitioners or people who wanted or were interested in being sole practitioners to make a transition similar to what I did, or maybe even directly from law school to a solo practice focusing on appellate law. So I'm happy to add what knowledge I've gained in that area to SPU, and hopefully folks will find it helpful. Since I opened my solo practice, I have not looked back even one time. It's been a really great experience for me. It's been a good fit for my particular personality, and it's been good for my family and on a number of different levels. So for those of you who are considering making that move, I congratulate you first on making the decision or making that consideration, but secondly would certainly encourage you, if you feel like it will work for you, to do it, because there's really no reason in this day and age not to, especially with the economy being the way it is and with law firms being as unstable as they are. And we'll get into that in a little more detail. I do speak on sort of the CLE circuit from time to time, and so I'm not uncomfortable speaking in public, certainly, appear in court and make oral arguments and do those sorts of things. But this circumstance is a little different, with me basically speaking to a camera, and no immediate feedback, no facial expressions, that sort of thing coming back to me. So if I feel, or if I look a little stiff or awkward, I apologize for it. I could crack a joke if I were speaking in a room full of live people, but I don't have that luxury today, and so I'm going to kind of plow through this and see how it goes, and ask you just to kind of bear with me on some of a little bit of awkwardness dealing with videotaping or videoing for presentation later, and hopefully it will be informative. And I would like to solicit the input of students and those who are looking at the SPU course, and would encourage everyone to do that, because that will help me tailor the course a little more to the needs of the individuals who are watching. So with that, let's move on to the next slide, which should be slide 3, and it should be headlined Syllabus. And so we'll talk in some detail about the syllabus and go through it. I haven't posted it word for word on the slideshow, but we'll hit the major points, and I'll probably reference some of those points, even the more minor points, as we go through covering the syllabus today. The syllabus itself is posted in my SPU classroom. Excuse me for 1 second. I've got a copy of it here. It might be good to refer to it. Yes. The syllabus is posted in the SPU classroom. I've tried on this slide to link to some of the areas that I'm talking about on the Appellate Practice and Procedure classroom site. Hopefully those links will work when you're logged in and clicking through them to the pages. If you're not, right now I'm unable to do it because it wants me to be logged in, and it keeps taking me just to the general SPU page. If those links aren't going to work, I will eventually remove them from this presentation, and I won't use them in other presentations. But I'm experimenting for the time being to try and make it convenient for you all to refer to what I'm looking at, or what I mean to refer you to when I say, for example, SPU Classroom. So if by the time you view this, if that link is not appearing anymore as an actual hyperlink in the words SPU Classroom on the syllabus, it's because I wasn't able to resolve that technical issue, and I don't want to confuse anyone by having links that don't work in my PowerPoint. So with that said, we can get into some of the other issues. As I say here in the slide, the syllabus is really designed to be sort of an outline of the major subjects that we're going to cover, and we'll address those here momentarily. But I have designed it hopefully to also include enough flexibility to shape the course as it needs to be shaped. I also have put out some requests for feedback from students through the official study group that's linked here as well, or through another group that I created on the SPU page called the Appellate Discussion Lounge. And what I intend for those groups to do, the official study group, of course, will be tied to the course and the actual subject matter that we're going to deal with in the course, point by point on the syllabus. And maybe this is somewhat duplicative, but I wanted to take advantage of some of the features that Susan and David had added to the SPU page, and so I created the Appellate Discussion Lounge really as an informal place to ask questions that didn't necessarily have to do with the point-by-point subject matter that would be covered in the syllabus. So feel free to use, I don't mean these to be limiting in any way, feel free to use either one of these to start a discussion, to ask a question, and I hope that you all will provide that sort of feedback so that I can address topics in advance, or well, I should say that a little differently. if you will send me your topics in advance before a course begins, before a course, say, on briefing, if you have a question about briefing, I'll do my best to address that question in the lecture that's relevant to briefing so that I can tie your specific questions to the course content, even though what we have here is not a two-way discussion in the same sense that you would have if I were actually standing in a classroom in front of all of you. So there are some limitations in this format, but there are really minor limitations, and I think based on what's been set up on the SPU page and the communication devices that are there, we can certainly make this as interactive as we can. And I also haven't mentioned, I do have office hours posted on the SPU course site, and right now they're basically every Friday at 10 a.m. Central Time, and I make myself available for an hour. But anytime you have a question, and if it's not within my regular office hours, so that I have given everyone the green light to just call me, just shoot me the question through the communication devices that we have available through the SPU webpage, and that way I will have it all in one place so that I can go back and look and see if there are questions that I need to address without having to filter through email and that sort of things. I do want to encourage phone calls during the regular office hour time. Please feel free to pick up the phone and give me a call to talk about whatever issue, course related or appellate related, that has come up for you or that you're interested in learning more about, and I'll do the best I can to get you an answer or just to give you the benefit of the experience that I've had over the last number of years. It's adding up more and more, it seems like. So please don't hesitate to take advantage of that. I haven't, on this slide that we've had up, the syllabus slide, I have not talked about yet the perspective that I am coming from with respect to this course. I've not taught this course before. I've created this course specifically for SPU at Susan's request, and it's something that I'm trying to give a fresh look to. I didn't want to go and adopt somebody else's syllabus from another course, although there are appellate practice and procedure courses taught in law schools. Certainly where I went to school, there had been an appellate practice and procedure course taught that now apparently isn't being taught as much anymore. But I went around and solicited some input from people, but I have created this course specifically with the sole practitioner in mind, and drawn up the syllabus with that being my main perspective, is coming at this from someone who was either going into solo practice or who was interested in solo practice, and to be able again to provide the benefit of the experience that I've gained in the last 3 years as a solo appellate practitioner. But what I want to emphasize here as far as the course perspective also is that this course is designed for you, and that ties back to my goal, as I think I expressed a moment ago, but let me be absolutely clear on what that is. My goal in this course is to meet your needs as a student at Solo Practice University and give you the information that you want and that you need to either make the decision if you're on the fence about going out into solo practice, or to make the jump and implement the things that I talk about in this course in your own practice, or to benefit an existing sole practitioner. So again, the goal, the idea here is to be flexible, to try to provide information that you as a student would find useful and hopefully informative, and maybe even provide things that you haven't thought of in terms of considerations as to why, for example, appellate practice is a good practice area for solos, which we'll get into here in just a little bit. We have, in terms of the format of the course, we have planned a total of 8 lectures, including today. Again, as I mentioned, as far as formatting, if you're watching this now, this is basically the format that I intend to follow. Susan has left the discretion for technology and presentation to the respective instructors. I'm going to say professors. That sounds a little bit presumptuous. I'll call myself an instructor. But this, so far, to me, seems to be the right format within my individual technological limitations, so that I can actually not just be a voice on a phone line, but give you, a little bit more than that. It is not going to be a studio quality video presentation. You can see me face to face, sort of, and follow along with the slides so that it's a little more interactive than it could be just with, for example, the headshot on the video and me talking. That I don't consider myself interesting enough to listen to for an hour at a time. So hopefully this will be something that will help and will engage you and hold your attention, and something you will learn from. Okay, let's talk about the syllabus. If you go to the next slide, the beginning Roman numeral number 1 appears at the top there, and that really is, these two Roman numerals, I should say, are really what we're going to talk about today. We're going to I've basically already given you sort of a rough overview of the course, and if you tack on what we're going over about the syllabus, that will sort of cover that general topic. But I do intend to speak about the reasons why folks would be interested in practicing appellate law. And I've given that some thought uniquely from a sole practitioner perspective as well. And then the second item I want to talk about today is the sort of anatomy of the appellate process, and we'll get into that shortly. The Roman numeral 2 that you see there, tools of the trade, that is, I do want to speak a little about the technological capabilities and so forth that are particularly useful in this practice area and that are available much more commonly now than they used to be, and make it one of the reasons why I believe that sole practitioners are particularly well suited. Well, maybe I'll say it the other way. Appellate practice is particularly well suited for sole practitioners who have some basic capabilities in terms of technology. So, just quickly we'll run through those. Actually, I won't run through them now because we're going to cover those in a lot more detail toward the end of the discussion today. So let's save that time now, and we'll get into those. If you'll move to the next slide, which starts with Roman numeral 3, this is where I'm getting more into what we're going to see in future courses. So Roman numeral 3 we'll cover in class number 2. That is how appellate lawyers bring value at the trial court level. And you see the subject matters there that we'll be talking about. I've had the benefit of experience not only in engaging in these kinds of things as a solo, but also having been a large firm lawyer, doing the same sorts of things, and being able to apply them in different settings. And so the third class will be made up, and this is sort of getting into what I would call the meat of the course. The third class will consist of what you see here in Roman numeral 4, making the decision to appeal, matters preliminary to an appeal, and that sort of thing. That'll be class number 3, class number 4. Going to the next slide. And class number 5 will actually focus on preparing briefs. So Roman numeral 4C that you see here will actually spend 2 full classes talking about the art, I would call it, of preparing briefs to be filed in appellate courts and relied on by the appellate judges in making decisions in appellate matters. Class number 6 will focus on oral argument and the decision, which is Roman numerals 4D and 4E that you see here. In Roman numerals or subparts F and G, rehearing and higher court review will constitute class number 7, and we'll wrap up with what you see as Roman numeral 5, tips and strategies for marketing and appellate practice. That is a significant part of the course. It's marketing is essential, obviously, to developing an appellate practice. And while these are some of my favorite things to talk about, marketing, because on a daily basis it's something that I do, and it's something that I think I've learned a lot about over the last 3 years or so, from a totally different perspective than what I had as a big firm lawyer. I'm saving that for the end because I think if folks don't figure out from reviewing the earlier parts of the course, sort of the as I say, the meat of the course, and really learn what appellate practice is all about, the marketing aspect of it, if they're not interested in pursuing that, the marketing aspect of it won't really make any difference to them. So stick with me for the whole course, please do, and I'll save what I get the most excited about talking about, and I maybe even call the best for last, for the end of the course. So and otherwise I'll just refer you to the syllabus, which is in more detail than what you see in these PowerPoint slides, and you can kind of get a feel for the sorts of issues that we'll be talking about, such as jurisdictional questions, appellate timetables, filing notice of appeal, putting together the appellant's brief, the appellee's brief, and a reply brief, and that sort of thing. Those are subjects we'll be covering in some detail. Okay, let's move into the slide now that has the heading, Why Practice Appellate Law? This is something that I think will interest most everybody who's watching this and is interested in this course. And maybe the thing to do is to start off just with an explanation of what appellate law is. It can be a lot of things, but the way I like to describe it is as practicing law as a quote-unquote law lawyer. Appellate work is a litigation practice that focuses on legal issues and to some degree procedural matters that come up in cases in litigation, rather than the factual development of the case, witness preparation, expert witnesses, in sort of preparing those sorts of folks, for example, to give depositions, interviewing fact witnesses and that sort of thing. Rather than focus on building the case factually, an appellate lawyer often tries to build the case from a legal perspective. And lots of trial lawyers do similar activities in preparing cases for trial. There is particularly a role to be played by appellate lawyers in trial work. But appellate work, generally, appellate law is focusing on the legal issues in a case, not only in the trial court, but obviously in appellate courts, presenting arguments, written arguments, and oral arguments to appellate judges who then make the decision in the case. And that the latter description is really more of what we think of in terms of an appellate practice, as someone who writes briefs, maybe makes oral arguments in the courts of appeals, or the state high courts or federal equivalents, and then deals with those decisions after they're released. It's really much more broad than what the ordinary concept of appellate law is. Another way of simplifying the description of appellate practice is an appellate lawyer is someone who talks to a judge a lot more than they talk to a jury. That's certainly the case in my practice, even though I am in the trial courts pretty regularly. Most of the time, what I'm dealing with, or who I'm dealing with as an appellate lawyer, is the judge, and I'm talking to them about legal issues in the case, or an application of a legal issue to the facts such that it would impact either an interim ruling of the court that would have a broader effect on the case, the end result of the court's decision, such as the outcome of a trial, or in pure I say pure appellate practice, where we're dealing with courts of appeals, making the legal arguments to what is most often a 3-judge panel or a full panel of the Supreme Court, in the Texas Supreme Court, for example, and asking for a ruling on the merits, or a ruling on some other legal basis that is dispositive of the case. So I haven't ever sat down and thought about, what the true parameters of being an appellate law lawyer are definitionally, but I think as a practical matter, appellate lawyers, there are plenty of us around who do a lot more things besides just write briefs and present oral arguments to appellate courts. So that said, why would someone want to get into this practice area? What does it have to offer? Well, as we see first in the slide here, and these are just 3 concepts that I've come up with as far as reasons why I think people like appellate practice and want to do it. And they are flexibility, variety, and marketability. We'll just take those one at a time. From the flexibility standpoint, appellate practice is, compared to other types of litigation, it is a lot more user-friendly and a lot more manageable. Early in my career, and even as recent as just a few years ago, when I was working with a firm, appellate practice was not everything I did. I had litigation cases, did trial work, traditional discovery, depositions, and all that sort of thing. And I can compare and contrast the two. I think I feel like I'm pretty well qualified to do that. If you have a litigation practice currently, you know what I'm talking about. If you're in the throes of working a case up for trial, you're going to have depositions, you're going to have discovery, lots of different deadlines. You're going to have opposing counsel sending you, motions that were unexpected, setting hearings on various things, and there's a lot of activity generally in your caseload, especially if you carry a fairly large litigation caseload. That's not to say that there's not activity in appellate practice. It's just different. What you see is more regulated, more, I say, even regimented. There are not as many milestones in a given case on appeal. If you want to talk about cases from purely an appellate, handling an appeal perspective, there are fewer events that take place. There's not discovery. You don't have a lot of hearings. Generally, the big hearing that happens on an appeal is the oral argument, and so the calendaring that comes up, or the nature of the case management is different than it is in, say, what I call a traditional litigation matter. That observation is not always true when you're down in the trial court and dealing with legal issues in the trial court, as I just described a few minutes ago, which is certainly a major function, I think, of an appellate lawyer. But for the most part, one reason why people are attracted to appellate work is you're not dealing with quite as crazy a schedule as you might have in dealing with traditional litigation, even though it's not necessarily a simple schedule or one that is boring. Most certainly, it's one that you have more control, I guess is one way to describe it. Generally, deadlines are somewhat flexible, especially if you can negotiate, for example, briefing extensions if you need to with the other side. It's a lot more controlled, and again, I think user-friendly is a good way of describing the practice generally. Another major reason for that is because most other people doing that kind of work value those benefits to appellate practice as well, and I think the side effect of that is you wind up with a much more collegial appellate bar, than the trial bar necessarily winds up being. So in Texas, for example, we have a relatively tight-knit group of appellate lawyers, and most of us know each other. Not only locally here, for example, where I am in Austin, but statewide. And we all go to the same CLEs, and we're on the same committees, and we have a very active state bar appellate section in Texas, so that it's really easy to get to know people that you might be up against or that you have been up against in cases, and that's a very useful thing. It helps to develop the collegiality among people who practice in this area, and so that makes practicing appellate law a little easier than it could be if you were not facing or likely to face the same people over and over in a particular litigation area. So under flexibility, I've listed that it's more manageable than other types of litigation. I think that's true. And then because of the way the deadlines are most often structured, is depending on the case and the specific tasks that you're involved in, appellate work is one of those areas where it is possible to maintain what I would call a more traditional work schedule. If you know far in advance that you've got deadlines, you know what you have to do to meet those deadlines, and there are not going to be as many surprises come up along the way, then maintaining a sort of regular business hour type of practice it's not always doable on a daily basis, because there's going to be things that come up in lots of different cases that require immediate attention. But my reference point again here is comparing this to a safe, traditional trial practice, and appellate practice is much more flexible and manageable from a time perspective. The second major advantage, I think personally, to appellate practice is variety. I like to say that appellate lawyers are sort of the last of the generalists, and I say that because so many areas of litigation we see so much specialization. For example, personal injury in Texas, there's a specialization for that. There's specialization for consumer and commercial law. There's a specialization for civil trial law, oil and gas, family law, lots of different substantive. Well, I guess civil trial wouldn't really be a substantive area, but there's lots of specialties available and specialists who try and limit their practices to those substantive areas, and family law is a good example of that. As an appellate lawyer, you're not, even though you are a specialist, and you have to use that term very carefully depending on what your state bar rules say. If you are practicing appellate law, that really goes more to familiarity with the appellate courts and the process than it does to any substantive legal area. So the practical effect of that is that you wind up working on cases in lots of different substantive areas. In my caseload, for example, I've got breach of contract and fraud cases. I've got some fair amount of real estate disputes that have come up lately. I've done legal malpractice work. I've done personal injury work. And all of these are areas where I have to have, in order to present the appeal or defend the appeal, I have to have a reasonably good command of the substantive law of those areas. But what I or any other appellate lawyer bring to the table, ideally, is having a unique and very detailed knowledge of the court system that we're in, and the procedure that goes along with that, the players, the actual judges in those courts, and that's really what I'm trying to emphasize here. Is it's not boring. You wind up with experience and exposure to a lot of different substantive areas of the law that, applying the skill set that an appellate lawyer brings to the table, you have the privilege of getting to learn, so that you're not sending out, comparing it again to trial practice, you're not sending out the same set of discovery or answering making objections to discovery, the same old objections 20 times over. There are certain things that you will see in briefs or in appellate work that are somewhat repetitive, standards of review, for example. But for the most part, you're writing, if you're writing a brief, you are researching and writing something that's its own unique animal, and it won't be replicated on all fours with another case, at least not frequently. So it keeps it interesting to be able to learn new areas deal with new statutes and recent developments in the case law that can impact your practice. So, and then finally, as far as what's good about or why practice appellate law, marketability is another major factor. We have seen an increase in the trend towards specialization, and so that trial lawyers, it's not quite like it was in the old days when you had the country lawyer who would handle probate matters and family law matters and civil litigation, and if they had cases go up on appeal, they might handle them themselves. Trial lawyers are focusing on what they do best. Family lawyers, some of whom are trial lawyers, are focusing on what they do best. And so to do that, they look to folks who specialize in other areas to complement their practices. And so one of your best friends as an appellate lawyer is a busy trial lawyer, because that person is a fairly good referral source for you. And this is sort of crossing into the marketing aspect of appellate practice. Making friends with trial lawyers is a logical thing to do because they're a very good potential referral source, and they appreciate you. They appreciate what you do if you can help them in their practice in a way that makes sense. And I think as far as marketability is concerned, we're all familiar with what the legal market is like now, the climate, what it's been like for some time, and looks like what the trends are going to continue to be. And so from a practice standpoint generally, to be able to offer someone a specific type of service that they can plug in to their own practice and do it efficiently, I think is a big plus. And the trend that I'm seeing and that I'm hearing about is that solos, small firms, and mid-sized firms are benefiting or expected to benefit from some of the trend of general counsel wanting to save costs and not necessarily hire the biggest law firm in the country to handle matters that just don't require that kind of firepower. So that's not to say that the solo appellate lawyer can't do a great job in a big case, because that's absolutely not the case. But the point is that there are some emerging marketing opportunities that seem to be coming or that have come, and now might actually be, or would be, in my opinion, a good time to consider opening a solo appellate practice. And the issue there being, of course, finding a way to market to those sources that might be potential clients and referral sources. So that's a subject for another lecture. Another reason that I haven't listed here for practicing appellate law is it does tend, this I guess ties into the flexibility issue, but it tends to attract people because of the nature of the practice, who want a little more control over their schedule, and who maybe even want to work part-time. For the reasons that we've already discussed, this is one of the few litigation areas where that option is really possible. It's much more possible to be a part-time appellate lawyer than it is to be a part-time trial lawyer, just because the day-to-day demands on a trial lawyer's schedule are much more intense. And now, an appellate lawyer can have a lot of demand on their time working on cases, but they're usually not dividing their time among 25 cases like trial lawyers are. And so because of the manageability, what I think is an increased manageability in an appellate lawyer's schedule, it does tend to attract folks who want to stay at home part-time. A lot of mothers of young children have selected appellate practice as a good fit for them, and it makes logical sense to me why that would be the case and why it would work, because the nature of the practice is such that it lends itself to a little better, more manageable time schedule. Okay, the next slide we've got up here is anatomy of the appellate process. This is a grossly oversimplified description of what the appellate process is in most jurisdictions. In my experience, having done some work in jurisdictions other than Texas, I've had a matter in California, I've had a matter in a few other states, and then of course in federal jurisdictions. This is pretty much how it works as far as the overall process. There could be some variety from state to state, but what this is intended to do, and what this discussion that I'm moving into now is intended to do, is just to give you a little bit of a snapshot of what the appellate process is and what one could expect if you're not familiar with it to see as an appellate practitioner, and just to give a little perspective on what it is we're talking about. In law school you read a lot of appellate cases, and those cases, the appellate court is reviewing some action of the trial court, but you don't really see, like you do in appellate practice, you don't really see much about what's going on in the trial court or see it from the perspective of the trial judge as you would if you were actually an advocate in those proceedings. So one of the things I wanted to try and do was give everyone a little appreciation for what trial judges, what their role is in this process. And so again, to oversimplify it, the first step that nothing can happen without is that the trial court issues some kind of reviewable order or judgment. That judgment, someone takes the steps, the procedural steps necessary to initiate review in the appellate courts, and then eventually the parties put together their arguments. In the appellate court decides the case, and then the question at that point becomes, and even setting aside the economics of it, which is a whole different deal, but the question then at that point is there another level of review that could be considered, that should be pursued? And so it's essentially, in most jurisdictions, the appellate process is a three-step process in terms of where you go in the courts that you're in. You're dealing with the trial court, you're dealing with what we have in Texas as intermediate courts of appeals. Usually they are courts where the appeal is a matter of right. There's no discretionary jurisdiction. And then finally, above the intermediate appellate court level, in most jurisdictions you have a Supreme Court or equivalent. And it's really the same sort of structure as what you see in federal court. And in those high court situations, many times you have a discretionary jurisdiction type circumstance where the appeal, if the appeal is pursued above the Court of Appeals level, or intermediate appellate court level, it is not as a matter of right. It is sort of a certiorari type jurisdictional exercise where the high court decides, picks and chooses or cherry picks cases that it wants to decide for various reasons. So moving to the next slide, what I've done is I've kind of given some examples of some pleadings that would be filed and some briefs and things that one would see in a case, just looking at the appellate process from the ground up. So, for example, here we have a final judgment in a case that I worked on, and this is where you're getting the reviewable order or judgment that sort of kicks off the appellate process. Now, again, there's lots of things appellate lawyers do that don't necessarily involve just challenging a judgment or just trying to defend a judgment. There's a lot of work that an appellate lawyer can do leading up to the point of the rendition of a judgment, or entry in federal court is the term you would use, of a judgment. But this is the reason I wanted to point this out for purposes of today's lecture, is this is not ordinarily the kind of thing you would see in a law school textbook. And you wouldn't really, unless you took a trial advocacy class, or had a class focusing on trial procedure, this is really something that would sort of be the starting point for an appeal, rather than something that an appellate lawyer would have worked or had any role in putting together. And there are roles, as we'll discuss later in the course, for an appellate lawyer to play in putting together a final judgment. But from again, a pure appellate practice standpoint, the sort of the starting place for getting involved in a case is the issuance of an appealable order or judgment, or an order that is somehow reviewable in some other way besides a traditional appeal. So, ordinarily that would involve final judgments or appealable in most state courts, also in federal court. Certain types of interlocutory orders. The best example that comes to mind is an order granting a temporary injunction. A lot of states have statutes that allow certain orders like that to be reviewed on an interlocutory appeal, even though it's not a final judgment. The federal system is the same. There's a statute allowing review, the circuit courts to review those. And then by other types of review, I mean things like mandamus or prohibition, or we have a number of other writs in Texas that allow, in certain circumstances, the appellate judges to review, sort of check the trial judge's homework, so to speak. For example, a writ of mandamus is designed and it's a very limited writ, supposedly. The law has shifted a little bit on that in Texas in recent years, but the idea is that the relator, the person who pursues the mandamus, wants to obtain relief before waiting necessarily for a full-blown trial, because the trial judge has abused his or her discretion is one prong of the standard, and secondly has that the litigant have no adequate remedy at law. And so there are those other kinds of procedural devices besides final judgments and interlocutory appeals that present opportunities for appellate lawyers to get involved in a case and to seek review of a trial court's ruling. Taking the same case, the Softtech International case, I'm going to show some, just as examples, some different pleadings at various stages of the process, just to again illustrate the snapshot of the appellate process. Here, what you're looking at is the notice of appeal, which is the device that actually jurisdictionally creates jurisdiction in the appellate court upon filing and paying the filing fee and that sort of thing. It's an example of the instrument or an instrument that perfects the appeal, that starts the appellate process. And one of the things to be particularly mindful of in dealing with filing an appeal is that in every jurisdiction I'm aware of, there are very strict procedural rules that apply in those situations, so that if you are unable or if you fail to comply with those rules, your client's rights will very likely suffer and be impacted in a very negative way. If the appeal is never perfected and the Court of Appeals never requires jurisdiction, then the decision cannot be reviewed, and you get the picture. It can be very the ruling or the outcome can be very adverse to the client who wants to challenge that trial court's ruling. After filing a notice of appeal and doing some other procedural issues, that, for example, ensuring that the record appears up at the Court of Appeals, one of the next big steps, and probably the biggest critical step in an appeal, is the preparation and filing of appellate briefs. And again, in this same case, I just give you a snapshot of our appellant's brief as an example of what, just as a cover page, would look like for those. Any of you who've been through law school, and I assume that's 99.9% of the audience, you had most likely in your legal research and writing course, you had to prepare an appellate brief. Well, this is the real world version of that, and it's not always the same as what you saw in your either your moot court problems or your legal research and writing problems. But I think anybody who's been through that has a basic understanding of what a brief is, and I think its basic function. We're going to talk about those subjects in a great amount of detail toward the middle of this course, and we're going to spend a couple of courses just talking about briefing, because conventional wisdom in appellate practice is that briefing, the briefs that you file are the most important aspects of representing a client on appeal. The courts of appeals or Supreme Court, whatever the appellate court is going to base its decision largely, if not entirely, on the presentation in the briefs. And so that is why it is important to, as we'll discuss momentarily, to be a good writer and to be able to pick and choose issues, points to present that are the strongest ones you can present. And in the briefing part of the course, we'll talk about sometimes you have to make hard choices and recommend to clients that they drop arguments that are not necessarily strong and that would potentially only dilute or divert attention away from arguments that are more likely to lead to a positive outcome on appeal. So we'll get into that later in the course. And then finally, the last step, as I'll describe it in this stage of the process, going to the next slide, the appellate court issues its decision. And here, this is again an example in the same case that I've been relying on as an example for you. The Court of Appeals rendered its decision, and the parties are informed of that, and then at that point, the client, after consultation with the lawyer, the parties have to evaluate whether to continue, if there's another level of review possible, whether to pursue that. And there are many reasons not to do that in certain cases, especially if you're dealing with a discretionary jurisdiction situation. For example, in our Supreme Court in Texas, and then the next slide, being a little bit facetious, but I've given you a snapshot here of the Texas Supreme Court. The Texas Supreme Court hears about 12 to 15% of all the cases that are filed there. And you can look at that a few different ways statistically, but in terms of advising a client on how to go about or whether to pursue higher court review after an intermediate court reviews the case and makes a decision, the statistical chances of getting relief certainly play into that. And especially if your client has just spent a large sum of money hiring you to prosecute an appeal or to defend an appeal, and if it comes out the wrong way, and you're looking at having to seek review to reinstate what was done in the trial court, cost is a major factor, especially when weighed against the odds of obtaining relief. And so we won't be able in our course to get into those kinds of strategic decisions. It's something that comes with some experience. You'll be able to advise your clients on, by studying your own jurisdiction and the court system there, and hopefully by getting not only just general statistics, but just getting to know the court. You'll be in a position as an appellate practitioner to advise your client on whether to pursue, whether it would be advisable to pursue a particular review in a particular case. You can't always base it just strictly on statistics, and you sometimes will have clients who want to just fight the battle no matter what. If they're paying and can pay, that's a good thing. Sometimes you have to tell your client, look, the Court of Appeals decision isn't perfect, but here's the standard review that the Supreme Court is going to apply if it even takes the case. And you have to get a little pragmatic and realistic with clients sometimes. And if they still elect to go forward, then that usually for you as a practitioner is a good thing. But setting client expectations is something else. It's sort of its own art in appellate practice. And so I don't think I have that formally addressed in any of our course materials, but if someone wants to chat about that in more detail, I invite you to contact me through the SPU communications systems, and let's just chat about it, or call me in your office hours and we can talk about it some more. Okay. Well, the other major topic that we have for today, and actually the last major topic that we have for today, is a discussion of the tools of the trade. What do you need, what kind of capabilities do you need to have to be a successful solo appellate practitioner in today's world? The first slide I have on this starts with computer and high-speed internet connection. So that's what I'll be speaking on for the next few minutes. This is actually, I think, the best possible time, technology-wise, it is the best possible time for someone to be considering going out and forming a solo appellate practice, because the tools that are the most useful to you in that practice area are widely available to you now. And 10 years ago, they were not. The impact and the power of the tools were not as widely available at that point. We have today, for example, having a high-speed internet connection, as I list here in the slide. What you need as a solo appellate practitioner to do your job, really, aside from the other details that I give here, are a computer, a high-speed internet connection, and a printer. If you have those three things, that's about 95% of what you need to do your job on a daily basis. And so, of course, one of the benefits of that is if you have a laptop, which, as I point out here, offers the most flexibility in terms of the computer arrangement. If you have a laptop, lots of places are hooked up with Wi-Fi now. You can work out of your home pretty easily, depending on your home arrangement, of course. You can go to the local library. You can go to the local coffee shop, the local bookstore. There are lots of places that you can go to and get connected to the internet with a high speed and do your legal research and writing and other things that you need to do as an appellate practitioner, with tools that are just readily available to you now. And even when I started practicing law in the 90s, there was no Wi-Fi. Everybody had dial-up connections. DSL was just kind of coming on the scene, and it would not have been as easy for me to start my practice, the practice that I have now, with the tools that were available back in when I finished up my clerkship. It was 1997, and it just would have been a lot different. And there were people who were solos who did appellate work, but they were using the same tools as everybody else. And yes, Lexis and Westlaw were available and that sort of thing, but now the speed of computers has increased greatly. The speed of the internet connections has increased greatly. The price of computers and other equipment has dropped substantially. With a relatively small investment in overhead, you can start an appellate practice as a solo. And so, as far as what you have, what your office arrangement is, you have to make the best decision for yourself as far as desktop or laptop. Again, laptop, to me, offers the most flexibility, and if you travel at all for your practice, it's really essential. But if for no other reason, then sometimes you just want to, work out of the library for half a day or something. You have the information available to you through that device, and it's almost irrelevant whether you are on a network or all your data resides on your hard drive, because of the way that the technology is evolving now. You can even access information on a network very readily. There's different software packages available out there to help you do that. So I'm a big advocate of the laptop, just because for me, if I want to work at the kitchen table or read email, at night and respond to email at night sitting on my couch in the living room, that offers me the best of all possible worlds. So, and in terms of other equipment to go with a laptop, I outfitted myself with a docking station and a widescreen monitor, and a wireless mouse. I use PC compatible products, typically, just because that's what I've been using for years. And I know that I have some of my fellow faculty at SPU will chide me for that, but it's what I know, and I tend to, because I'm not on a network, I don't tend to require a lot of support and a lot of I don't have a lot of crashes or any problems like that. So while some people would advocate Macintosh, and I personally think it's something that someone ought to consider who's starting an appellate practice. They ought to consider Macintosh products or Apple products. For me, the easy decision was to go with a PC compatible, or I have used Dell products as a good Austin company. So I got the port replicator / docking station, a nice external keyboard, full-size keyboard, and a good widescreen monitor and a wireless mouse. And I plopped down at my desk, popped the laptop in, plopped down at my desk, and it's functionally now it's the same as having a desktop computer, which wasn't always the case. So again, the advances in technology have made it to where you're just a lot more portable generally in practice as a solo. And so for that reason, it's another reason that solo appellate practice is a good practice area for someone considering going out on their own. And the technology sort of complements that arrangement as well. The technology that's available to you really makes it a lot easier than it once was, and a lot more possible. I also mentioned here Wi-Fi. I mean, Wi-Fi is kind of an essential if you're with a laptop, but you can find enough hotspots nowadays. Barnes and Noble, whatever bookstore, again, the library, that it really is an essential to have your own wireless card. I don't. I managed to work around that if I'm going to be working away from my office. But that's a consideration. The wireless cards are getting inexpensive enough and reliable enough now that that's another possibility if you just want to have a reliable internet connection and not have to depend on getting into somebody else's free Wi-Fi or similar type arrangement, and that's a factor to think about. So aside from the hardware that you would need, computer and high-speed internet connection, and I left printer off this list, but that ought to be obvious. There are some other things that are really fairly critical to doing the job that are not hardware related necessarily, and I list here research databases as being one of those. As an appellate lawyer, you're going to be doing a lot of research and writing, and so you need access to sources that can get you the information you need in case law, statutes, regulations, and so forth to be able to put together motions, briefs, and all that. The paid subscription services like Lexis and Westlaw tend to be the most comprehensive, and personally I use Westlaw, and I have a flat rate subscription that I just consider that to be part of my overhead. I don't try and bill it back. I don't try to recover that cost from clients on a pro rata basis or anything like that. To me, that's just one of the costs of doing business. And I put that in my engagement letter to people and say, look, I have a Westlaw subscription that's flat rate, and I'm not going to charge you, per minute or per transaction or anything. And that's just part of the deal. And I think clients really appreciate that. They like not being nickel and dimed, and it is not inexpensive, the subscription that I have, but it's not prohibitive either, and it's comprehensive enough where really I rarely need to go anywhere else for the information that I need. I'm looking 99% of the time. I'm looking at a case law from a specific jurisdiction, almost always Texas, but sometimes other states. I'm looking at statutes, same type of situation, maybe a regulation, maybe a law review article. That stuff is all available to me in the subscription that I have to Westlaw, and I think Lexis offers certainly a comparable service that you ought to consider. I mentioned here low cost or no cost alternatives, and there are some good ones out there that are worth considering. Lowest Law is one that I'm familiar with. Casemaker is one that is available to other members of the Texas Bar just for free. You can go and research Texas case law for nothing, for having paid your bar dues through the Texas Bar's webpage. These do not tend to be, though, as comprehensive. The price is right, certainly on the free ones, and I think even some of the alternatives are very reasonably priced. And for most, well, for a lot of people doing trial work, for example, would be sufficient. You're not necessarily looking into the finer intricacies of the law of whatever the substantive area is that you're getting into. As an appellate practitioner, though, I think I would be very careful about relying on these for my primary source of legal research, because the Lexis and Westlaw are known quantities. Everybody who went to law school had a free subscription, probably both or one or the other, because the companies are very smart in their marketing and they want to get you hooked early. And that goes all the way back to when I went to school in the early 90s. We had dial-up Westlaw. It wasn't through Internet Explorer or Firefox or any of those others. It was like a dedicated portal, and it was a totally different animal than it is now. Just being able to just get on it as a web page and log in and you move on to your databases. So they do a great job of marketing, and I'm mindful of the fact that they're not the only game in town. But the truth of the matter is, and I know a lot of people who would agree with me on this point, is that they generally are the most comprehensive, and for the most part they're worth the price of admission. But I just want to make sure that folks know there are other alternatives, and it may be that these lower cost alternatives or no cost alternatives reach the point where they're legitimate alternatives to an actual paid Lexis or Westlaw subscription. I think in the information age that's more and more likely than it would have been 10 years ago. So next slide, moving on to other things that you would need as a solo appellate lawyer. Reference materials. I've given some examples here. O'Connor's puts out a number of very helpful books on Texas practice, not limited to appellate practice, but civil procedure, the Civil Practice and Remedies Code, family code, all these different areas. There's a very useful book they put out called Texas Civil Appeals, which kind of covers the range of appellate issues, really more from a procedural perspective, not anything substantive, because I think they rightly treat that separately. But it's a good example of a book that really ought to be on your desk if you're practicing in Texas as an appellate lawyer, just because it's very easy to pick it up and flip through it, and you don't even have to get on your computer to answer some question. And it's all organized by topic, and there's a subject index, forms that sometimes come in handy. It's something that just, the kind of book that you ought to just go ahead and invest in, if you at all can do that. West puts out a book that comes at things a little differently, but substantively has a lot of the same information in it. That's the Texas Practice Guide Civil Appeals that's mentioned here. Different states. I tend to find that jurisdictions have these sorts of books if they tend to have them more often if appellate practice is sort of a recognized specialty in that jurisdiction, and there are not that many, I don't believe. I think I'm kind of spoiled here in Texas because we do have a board certification in civil appellate law. I know California has the same or a rough equivalent, and Florida does as well. I believe there are other jurisdictions out there. So the bar, the people who write these books have an audience if they've got board certified appellate people in their jurisdiction, but hopefully it's not limited to those jurisdictions. And hopefully, if you want to go out and be an appellate practitioner in your jurisdiction, there are reference books like this available to you to just use as shorthand, desk resources to be able to pull and answer specific questions that come up in your practice. So look in your own jurisdiction to see what you've got. West obviously is a comprehensive source for this kind of thing. There are others as well. So it would just depend on who tends to be the leader in these areas in your jurisdiction. I would check and see what they have. And you may already know about some that I just would have no idea beyond Texas and maybe a handful of other jurisdictions. So, okay, the last tool of the trade we're going to talk about today is legal writing ability. That's something that I'm not really going to cover in any detail in this course other than to make some suggestions, but it is something that's absolutely critical to success in this practice area. Probably, if you're watching this video, you already have an assessment of your legal writing skills, and that is something that there's really no substitute for as an appellate practitioner. If you can't write a sentence, then you're in the wrong area. There's no other way to say it. If you don't think of yourself as a good legal writer, or if I don't want to put too much importance on grades in law school or any of those sorts of things, but if you haven't identified legal writing as a particular skill set of yours at this point in your career, I think I would really look hard at whether appellate practice is right for you, because it requires it not only requires talent, you have to be at least a good writer. You don't have to be an excellent writer or a novelist or any of those things, but you at least have to be a good legal writer. And so, without that skill, I think it would be extremely difficult to be a successful appellate lawyer, especially in a solo practice, because you most often don't have anybody to rely on but yourself in terms of putting out the work product. There are potential arrangements you can make with law students or contract lawyers to help put things together, put briefs together, and that sort of thing. But my philosophy generally is the client hires me, and they expect me to be the one doing the work. And except for some basic research, when I write a brief, I want it to be mine, and I want to be able to sign my name to it, and without any hesitation. And so, if it's someone else's product, it's not always as easy to do, even if it's good. But at this stage of the course, I would say if you're watching this and you have doubts about your writing ability, take a little time and think about it, because it's an area that it's a skill that you just really cannot do without in this practice. That said, there are ways to hone your skills and sharpen your skills, and I've given some suggestions here. I have a blog post that I did about a year ago after Wayne Sheese, who's the director of the legal writing program at University of Texas Law School, came and spoke to a bar group that I'm part of, and I put up a blog post kind of summarizing some of the tips that he had given that day, and he wound up writing about them later in his own blog. And hopefully, if these links work, as I was saying at the beginning today, I'm not sure that they will, and I'll take them out if they don't, or I will revise this to where they're not hyperlinked, but that I actually give the link, the URL. Take a look at this blog post, and there's some sources there. There's a focus that is offered on how to evaluate and how to improve yourself as a legal writer, and there are some resources identified there to go to and to learn from, and that's something that we can all do. And no matter the most accomplished appellate practitioner ought to be doing the same thing. But what I've tried to do is here and at the end of the syllabus provide some sources to go to that would be useful in terms of really not so much evaluating your legal writing ability, because hopefully you already have an assessment of that, but really more to self-motivated improvement of your legal writing ability. And again, any of us who practice in this area could benefit from studying and getting some mental exercise to try and improve ourselves in that way. So that really concludes the first lecture for Appellate Practice and Procedure at Solo Practice University. Next time, as I've indicated on the slide here, class number 2, we are going to cover in the syllabus the subject of how appellate lawyers bring value at the trial court level. And so I hope you found this first class to be informative. It's been sort of an overview of what we're going to do over the next 7 sessions. If you have questions, again, contact me during office hours or contact me through the SPU communications portals. I'd be happy to either answer your question one-on-one, or if it's something that would be appropriately addressed to the course, try and work it in at the appropriate time. So thank you for your attention, and look forward to seeing you again here at Solo Practice University.